Good morning, everyone. I'm going to call the Assembly Committee on Judiciary to order. Madam Secretary, would you please call the roll?
Assemblywoman Bilbray Axelrod. Assemblywoman Cohen.
Here.
Assemblywoman Gonzalez. Here. Assemblywoman Hanson. Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Krasner.
Here.
Assemblywoman Marzola.
Here.
Assemblyman Miller.
Here.
Assemblywoman Wynn.
Here.
Assemblyman O'Neill.
Here.
Assemblyman Orentlicker.
Here.
Assemblywoman Summers Armstrong.
Here.
Assemblyman Wheeler.
Here.
Chairman Yeager.
Here, please mark Assemblywoman Hanson absent excused, and also mark Assemblywoman Bilbray Axelrod absent excused. I think she's going to be just a little late in joining us this morning, so I'll try to let you know when she arrives. That means we do have a quorum. Good morning to committee members. Good morning to those joining us here in Carson City, and to those who are on the Zoom and who may be watching on the internet. This is day 81 of the 81st session of the Nevada Legislature. Before we get started on this morning's agenda, just a few housekeeping matters. For those who are in the room with us, if you could please silence your devices. And if you are here in the room and you're going to testify today, please make sure when you come to the table, you turn the microphone button on, you state your name, and then after you're done providing your testimony, please turn the microphone off. For those who are on Zoom, if you could please remember to mute yourself when you're not speaking, and if you could also remember to state your name each time before you speak, particularly when answering questions. That will make life a little bit easier for our very hardworking committee secretaries. We do expect courtesy and respect in our interactions with one another. We don't always agree on policy. That's perfectly okay, but we need to make sure we're being respectful of each other, of the legislative process, and of our hardworking staff. And then finally, keep in mind that many members will be using multiple devices to access this meeting, including iPads, their phones, their laptops. So please don't see it as a sign of disrespect if members appear to be looking away at various points during the meeting. With those matters behind us, we are going to move to our agenda. And committee members, we're going to take the bills slightly out of order due to some timing constraints a couple of our presenters have. So we're going to start with Senate Bill 71. So at this time, I will open the hearing on Senate Bill 71 in its first reprint. Senate Bill 71 revises provisions governing unclaimed property. I believe we have our treasurer with us on Zoom, and I do see him there. So welcome, Treasurer, Mr. Treasurer, to the Assembly Judiciary Committee. I think this may be your first time in the committee this session. I can't quite recall because it's been a long 81 days, but nonetheless, welcome to the committee. Go ahead with your presentation, and then I'm sure we'll have some questions.
Treasurer Conine, for the record, thanks so much for having me today. Good morning, Chair and committee members. For the record, I have the pleasure of being your Nevada State Treasurer, Zach Conine. I do believe this is the first time I've been in front of Assembly Judiciary, so maybe a high point for me, but we still have 40 or so days left in session, so maybe I get to come back. It's my pleasure to be here this morning to present to you Senate Bill 71. Broadly, Senate Bill 71 makes changes to Nevada's Unclaimed Property Statute in an effort to modernize and align Nevada's unclaimed property laws with national best practices and the Uniform Law Commission's Revised Uniform Unclaimed Property Act, or RUPA. Pursuant to NRS 120A, the Treasurer's Office administers Nevada's Unclaimed Property Program. In this role, the office takes custody of lost or abandoned property from individuals and business holders and works to reunite it with its rightful owners. When property cannot be reunited with its owner, it is held in perpetuity by the state. When you have a free moment, I would encourage everyone to search for themselves and their neighbors at claimitnevada.org to see if the state is holding on to any money of yours. While Valentine's Day is past, Mother's Day is coming up, makes a great gift. For scope, last fiscal year, our office processed and approved 38,368 claims, which resulted in a return of $46 million to Nevadans. On the holder side, last fiscal year, holders reported and remitted over $71 million in unclaimed property to our office. When the pandemic began, our office looked for ways we could assist Nevadans who were hardest hit and struggling. We teamed up with Dieter to use the unemployment insurance claimant list to cross-reference our unclaimed property database to determine if we were holding any unclaimed property for UI claimants. To date, this initiative has resulted in returning more than $2 million in unclaimed property to owners who are currently filing for unemployment insurance. We receive weekly reports from Dieter on new claims, and this effort is ongoing. Unless there are any questions at that point, I'll move on to a walkthrough of the bill.
That'd be great. Thank you, Mr. Treasurer.
Thank you, sir. Sections 2, 3, 7, 8, and 9.5 of the bill adopt language from the revised Uniform Unclaimed Property Act, or URUPA, to better align Nevada's unclaimed property laws with other states. The bill was amended in the Senate to add more sections of URUPA, thus bringing us even closer to the Uniform Law Commission's language. We would like to thank Senator Orenshaw for his efforts on that front. Section 4 of the bill allows the office to create a claim and deliver payment to the owner if we reasonably believe we have identified the rightful owner. Currently, the statute requires the individual to whom the property belongs to file a claim prior to delivering payment. At the beginning of the COVID-19 pandemic, as I mentioned, we started working with Dieter in cross-referencing the property databases. Our intent was to verify the information and remit payment directly to those individuals who needed it the most. However, given the requirements of statute, we instead had to send them all a letter indicating we were holding their property and instructing them on the process of filing their own claims. This flexibility will allow our office to more efficiently reunite owners of property. Our intent is to use this allowance under statute is limited in controlled circumstances like the one described above, where we have multiple points of personal information that match our database, such as birthdays, social security numbers, name, address, and phone number. Sections 5, 10, 15, and 17 of the bill simply make conforming changes to statute based on the changes in the bill. Sections 6 and 7(1)(n) clarify the definition of account of funds relating to the cost of burial. This terminology was adopted last session through Senate Bill 44. And after speaking with the industry and the Division of Insurance, who governs these pre-need contracts, we determined that additional clarity was necessary to ensure the intent of the law was achieved in the language. Section 9 updates existing language regarding the delivery of safe deposit boxes. Currently, the law requires that once a bank sends a report of the safe deposit box, they must wait 60 days before delivering the boxes to our office. As you can imagine, this creates inefficiencies for our staff, as we have to put all safe deposit box work on hold for 2 months. The updated language will require safe deposit boxes to be delivered within 60 days, therefore allowing our team to get to work immediately once reports are received. Section 11 allows our office to require proof that someone filing a claim on behalf of an estate has the proper authority to be doing so. The section also makes documentation received on behalf of a claimant confidential and not subject to public records. Collecting personal information is necessary to verify a claimant's identity and their relationship to property. We've included this change in statute to assure Nevadans that any personal information and documentation they share with us remains confidential. The inclusion of this language will also save staff time by allowing our processors to focus on claims rather than redacting records requests. Section 12. The change allows us to make property available for claiming once we receive it. Under existing law, if a holder of business remits unclaimed property prior to it reaching the appropriate dormancy period, usually 3 years, we must hold on to the property for the same amount of time the business would have. This issue most often arises when a holder goes out of business. Removing that requirement from statute will allow our office to connect Nevadans with their property when we receive it, rather than holding on to it for additional years. So in other words, if there was a business that sent a paycheck to an employee and then the business goes out of business right then, our office would have to hold on to that check for 3 years as opposed to giving it back to the employee. This would fix that problem. Section 13 allows our office flexibility in our efforts to notify holders of an audit. We make every effort to give reasonable notice. However, in limited circumstances, this can be impractical, such as when a holder has multiple locations and does not respond to a request to confirm the appropriate location to send notice to, or when a holder never acknowledges receipt of the notice. This section also allows us the ability to request copies of documents during an audit, rather than requiring our staff to travel on site to examine the originals. Furthermore, it grants us the ability to compel production of records through an administrative subpoena. These changes modernize our audit processes and focus our auditing staff's time on identifying reportable property rather than administrative back and forth. Section 14 requires holders of unclaimed property to hold on to a backup documentation that verifies their non-reporting of property. For example, during the course of an audit, it could be found that a holder has 10 uncashed checks that were never reported or remitted to our office. The holder could claim that they had canceled those checks, which would render them worthless and not reportable to unclaimed property. Under existing law, there's nothing in statute that allows our office to request backup verification, verifying their claims to prove the checks were indeed canceled. This would allow us the ability to do so. Section 16 allows error finders to receive a higher percentage of property claimed. Currently, several professional firms exist whose business is connecting individuals with their lost and abandoned property. These firms get paid a percentage of the property they've located through written agreements with the property owner. Existing law caps that percentage at 10%. This change would allow firms who connect owners of property older than 5 years old, most would have been abandoned or lost for at least 8 years because of that 3-year window we talked about before, to charge up to 20% of the property amount. Allowing for a higher commission better incentivizes these firms to find and connect Nevadans with their missing money. And the short version here is the longer a property is dormant, the harder it is to find the owner. And most often that's not the original owner, it's an heir, so a nephew or a second cousin twice removed. And it's harder for these companies to find the individuals, harder for the individuals to find out they have money. We want to make sure that we're creating incentives that match the additional work. This concludes my presentation. I thank you for your time and consideration of Senate Bill 71 this morning. I'm joined today by our Deputy Treasurer for Unclaimed Property, Linda Tobin, although our Junior Deputy, Teddy, had to go to school. We'll be happy to answer any questions you may have.
Thank you so much, Treasurer Conine. Before we take questions, I had a request from Senator Orenshall, who is with us on the Zoom. He wanted to make a brief comment about Senate Bill 71 as well. So if we could go to Senator Orenshall, I would appreciate that.
Thank you very much, Chair Yeager. For the record, James Orenshall, State Senate District 21, parts of Henderson, unincorporated Clark County. I want to put on my uniform law commissioner a hat this morning. As you and many of the committee members know, I, Assemblywoman Cohen, Senator Pickard, former Assemblywoman Backus serve as some of the uniform law commissioners for Nevada. And I want to thank Treasurer Conine and his staff, Eric Jimenez, Kristen Rye, and Deputy Treasurer Linda Tobin for working with uniform law commissioners. I believe we really were able to improve Senate Bill 71 and get us closer to the revised Uniform Unclaimed Property Act. So I do appreciate the Treasurer working with us and with the Uniform Law Commission on this bill.
Thank you so much for those remarks, Senator Orenshall. And Treasurer Conine, let me just say thank you for the work you've done and you and your staff have done on the unclaimed property. I think many of us up here in this committee have either found unclaimed property of our own or have found some for family members. And as you indicated, I think that is in large part due to the efforts that your office has made to publicize the fact that it's so easy to look yourself up and find the unclaimed property. So I just wanted to thank you, and I'm just very impressed by the amount of unclaimed property that has been returned, and I expect that to continue. So before we take questions, let me just acknowledge the very hard work you and your staff have been doing. Committee members, do we have questions on Senate Bill 71 in its first reprint? We can't let the treasurer off that easy. Okay, Assemblywoman Cohen, please go ahead.
Thank you, Chair. Thank you, Treasurer, and to your office for all the work over the last several months. My question is about on page 7. Let's see what section this is. Sorry, I usually try to write these down when they're in long. I'm just going to give you the line number. So at the bottom, line 39, sub 4B, that activity requirement, activity by an apparent owner. So how are we balancing the fact that some people don't have a lot of activities on accounts, but they know that the account is there, they just don't really use the account, like maybe it's an emergency fund, and so they just put it there and leave it. I've been contacted. I have an emergency fund in a credit union, and they want me to do something with that. They literally said that I needed to, just come in and put $1 in, that type of thing. I don't want to do that. I just want to leave the account alone. And so how are we making sure that people aren't having to jump through a lot of hoops on the accounts that they know are there and recognize are there?
Treasurer Conine, for the record, Assemblywoman, thank you so much for the question. And I'd be remiss if I didn't point out that the fantastic success we've had in the Unclaimed Property Program is completely due to our Deputy Treasurer, Linda Tobin, and her fantastic staff. So just wanted to get that on the record. I occasionally tweet about it, but that's the extent of my skill set there. On this specific thing, what we're trying to do is make sure that any touch of the account is effective. And that's a series of things. That could be the bank sending a statement to the house that doesn't get returned. That could be a person logging into an online account or viewing it online. That could be a transaction in or out. But the goal there is really anything that proves that the account isn't dormant, right? And the change to language here, including accessing the account or information concerning the account, is again just to try and widen the number of contacts that would count. And I'll turn it over to Deputy Treasurer Linda Tobin in case there's anything she'd like to add there.
Good morning, Chair and committee members. Linda Tobin, Deputy Treasurer of Unclaimed Property. For the record, to Treasurer Conine's point, that is the intent of this language, is to expand some owner contact to account for that specific scenario. There are some additional safeguards, in particular to banking type accounts, that owner activity on any of an account will constitute activity for all of their accounts. So that helps to safeguard against this as well, as does prior to any account actually coming to unclaimed property. The banks and all the other holders are required to send out due diligence letters notifying their customers of the existence of their accounts and ask for some acknowledgement and contact to give them an opportunity to, again, acknowledge those accounts prior to those ever coming to the state.
Thank you. I appreciate that, because I literally did have the credit union say that they were going to turn over the account if I didn't physically come in and deposit $1, even though we were on the phone and doing that type of thing. So thank you for that.
We'll go next to Vice Chair Nguyen.
Thank you, and it's always good to see you, Treasurer Conine. I have a question. Is there any way you can kind of like walk us through like what it looks like when you're talking about Section 2 and gameplay currency and your virtual wallets? Like, how does that end up in your office?
Treasurer Conine, for the record, I'll again take a shot here and then turn it over to Deputy Treasurer Linda Tobin if need be. So the goal here is to move closer to the Uniform Unclaimed Property Act, or Revised Uniform Unclaimed Property Act, RUPA. And specifically here, what we're trying to say is that the tokens that are created in a game don't ever get escheated. In other words, that if you've got V-Bucks in Fortnite, or you've got Pokecoins, right, because your Slacking has done a great job protecting a gem, that doesn't need to get escheated to the state, because there's no way we can functionally return it, right? So we're trying to make a very clear statement that if someone goes and purchases a skin in a game or something like that and then doesn't touch the game, that doesn't need to get escheated to the state.
Thank you.
And Treasurer Conine, one of the downsides of being on Zoom is you don't get feedback on your jokes, but they're going over very well this morning. So just know that we really appreciate it, especially at 8 o'clock in the morning on an unclaimed property bill. Thank you for making it entertaining.
Treasurer Conine, for the record, I appreciate that, Chair, though I frankly have never needed feedback to continue making jokes.
Do we have any other questions from the committee? Oh boy, it is Thursday. All right, I don't see additional questions, Treasurer. Thank you for the presentation. And what we'll do is ask you to just hold tight for a minute. We'll see how many hundreds of people we have on the phone line for this bill. We'll take some testimony, and then we'll come back for concluding remarks. So at this time, I'm going to open it up for testimony in support of Senate Bill 71. Do we have anyone in the room with us in Carson City who'd like to testify in support? I don't see anyone coming forward. How about on the Zoom? Anyone on the Zoom who would like to testify in support? I just think we have presenters for other bills. So it doesn't appear to be anybody there. BPS, could we go to the phone lines to see if there's anyone there in support?
Yes, good morning, Chair. To testify in support of Assembly Bill 71, press star 9 now to take your place in the queue. Once again, to testify in support of Senate Bill 71, press star 9 now. Chair, there are no callers in the queue.
Thank you, BPS. I will close testimony in support. I will now open it up for testimony in opposition. Is there anyone here in Carson City who'd like to testify in opposition? Doesn't appear to be anybody. I don't see anyone on the Zoom in opposition. BPS, could we check the phones to see if there's anybody there in opposition of Senate Bill 71?
Yes, to testify in opposition of Senate Bill 71, press star 9 now to take your place in the queue. To testify in opposition, of Senate Bill 71, press star 9 now. Chair, there are no callers in the queue.
Thank you so much, BPS. I'll close opposition testimony. I'll now go to neutral testimony. This might be where the action is on this one, to be determined. Anyone here in the room in the neutral position? No one here in Carson City. I don't see anyone on the Zoom. BPS, could we go to the phone lines to see if there's anybody there in neutral?
To testify in the neutral position on Senate Bill 71, press star 9 now to take your place in the queue. To testify in the neutral position on Senate Bill 71, press star 9. Chair, there are no callers in the queue.
Thank you so much, BPS. I'll close neutral testimony. Treasurer Conine, any concluding remarks on Senate Bill 71?
Chair, no, I just want to thank you and the committee, Treasurer Conine for the record, you, the committee, and our fantastic unclaimed property staff for their work. Thanks so much. Have a great day. I hope the rest of the hearing is exciting.
Thank you so much, Treasurer. Appreciate you being here and appreciate all the great work that you're doing. Have a great rest of your Thursday. Okay, I'm going to close the hearing on Senate Bill 71, and we're going to take Senate Bill 95 next, and you'll have quite a task to try to match the wit and jokes of Treasurer Conine, but at this time I'm going to open up the hearing on Senate Bill 95 in its first reprint. Senate Bill 95 revises provisions relating to business entities. We do have, again, Senator Orenshaw here with us this morning. We have Ms. Warren and Mr. Kim as well. So Senator Orenshaw and others, welcome to the Assembly Judiciary Committee. We are looking forward to a very compelling presentation on Senate Bill 95, and please proceed with the presentation, and then we'll have some questions.
Good morning, Chair Yeager, members of the Assembly Judiciary Committee. For the record, James Orenshaw, State Senate District 21. And if you thought unclaimed property was exciting, get ready for biz orgs, because you ain't seen nothing yet. Senate Bill 95 is actually a pretty exciting bill, even though you might not think so, because I think it will, if passed, help Nevada become more competitive in terms of attracting business to our state, more modern in terms of what's in our statutes, and keeping up with other states such as Delaware, South Dakota, Wyoming, that try to modernize their statutes to attract businesses and be business friendly in light of modern developments in technology. Chair, with your permission, I'd like to turn it over to some real knowledgeable experts in the area of business law who have helped me work on this legislation. But before I do that, I want to point the committee to a mock-up amendment that is on Nellis. We did amend this bill in the Assembly to try to work with different stakeholders. And there's a proposed amendment, which is on Nellis, which has a very small change. I proposed to section 22.5, which represents consensus language working with the Association of Resident Agents that I believe makes the bill better and addresses some concerns they had. So I do ask committee members to look at that mock-up. But with your permission, if I could turn it over to Mackenzie Warren and Mr. Robert Kim of the State Bar of Nevada Business Law section, who I've been working with on this legislation, and then I'm happy to answer any questions.
Thank you so much, Senator. Appreciate it. Ms. Warren and Mr. Kim, welcome to the committee, and please go ahead.
Thanks so much, Senator. Good morning, Chair Yeager, Vice Chair Nguyen, and members of this Assembly Judiciary Committee. Mackenzie Warren with McDonald Carano on behalf of the Business Law section of the State Bar of Nevada. I have to give Senator Orenshaw a big shout out. Last fall, when I was hunting for a bill sponsor, Senator Orenshaw perhaps made the mistake of saying that geeky and wonky was his middle name. And I said, I've got the bill for you. I'm starting to see a theme this morning in how we've stacked these bills. But truly, as you heard the sponsor say, this is a highly technical area of law, but it's important. We want Nevada to be cutting edge. We want to stay competitive. And these are highly vetted changes. So just a bit of backstory on the Business Law Section Executive Committee. This is comprised of practitioners from all across the state that work in these statutes, and they encounter scenarios in their everyday practice. And they come up with little tweaks that we can be doing to make sure that our laws are predictable, that we're creating default rules that create a really good baseline in the instance where, governing docs may not exist, or perhaps they're silent on a certain point. So it really protects business entities, from an LLC all the way to some publicly traded corporation issues, and especially of note and very relatable to this committee and really the entire legislative body is meeting virtually. And there's a little bit of a quirk in NRS that we wanted to change to make sure that when in fact stockholder meetings are noticed and they're held virtually, that people can't get cute with the statutes. That's just one of the highlights. Luckily, I'm not really in the hot seat this morning, and nor am I the big brain on this bill. With your permission, Chair, I will turn it to Rob Kim, who, as the senator pointed out, there is a memo on Nellis that breaks the bill down section by section. We were grateful to be able to meet with many of you members yesterday to walk you through it. It's also available for the public, and Rob Kim will be taking us through section by section. Rob?
Thank you, Mackenzie. Robert Kim, here before you. I am a partner at the law firm of Ballard Spahr, and here in my capacity as chair of the executive committee of the State Bar of Nevada's Business Law section. I appreciate the time given here to the executive committee on this bill. I appreciate Senator Orenshaw for his sponsorship of our bill, and to Chair Yeager, Vice Chair Nguyen, and members of the Assembly Judiciary Committee. I plan to go ahead and go through the bill and go through the memo as well, just so you can have a small taste of the different things that we have put together. Unfortunately, in my years of knowing Treasurer Conine, I've realized there's no sense in competing with his humor, and just to basically laugh with him, sometimes in other ways as well. But I didn't have anything prepared as he did with respect to Pokemon references or otherwise. So unfortunately, I think I have to leave my humor at that, and then go forward and dive into the bill and get through it as quickly as we can, so give your time back. So generally speaking, the bill is a product of input from various practitioners on the committee, as well as those members of our bar who have provided us with feedback and suggestions and other concerns about our statute. And what we try to do is obviously take those into consideration, take into account just quirky things we find, corrections, some typos in a way, and also recognize different trends that we see in corporate jurisprudence throughout different jurisdictions, namely trends in the Model Business Corporation Act or trends in Delaware, for example. So what I'd like to do is just quickly run through the memo that has been provided that tracks SB 95, the first reprint, where we reference the relevant section of SB 95, the impacted NRS section, and a short statement as to what it is that we're trying to accomplish. So looking at page 3 of the memorandum, you'll see that the first item is meant to be a cleanup item relating to section 75-160, where we just merely shift the burden of providing notice to management who do not reside in Nevada, but are parties to lawsuits. We want to shift the burden from the clerk of the court to the actual serving party, just to make sure that there's no latent defect in terms of service of process of those individuals that have elected to use our state's laws, but happen not to reside in Nevada, but yet are necessary parties to litigation. So again, I don't think that is controversial. It's just meant to make sure that there's no gap and to alleviate the clerk of the court from that burden and shift it onto the moving party in the first place. The next item covers sections 2, 3, 7, 8, and 38 of SB 95 and relate to various sections in the corporate statute of Chapter 78. And what we've done here is merely take the existing definition of publicly traded corporation and move that forward into the definition section instead of having it tucked away in one of the anti-takeover sections of our corporate statute. Again, there has not been any substantive change. We're just moving it forward so that it is easier to locate. And obviously this is a nod to the fact that publicly traded corporations are more prevalent more people are comfortable with them, more people invest in them, more people have relationships with publicly traded corporations. So we thought it appropriate just to move that forward so that it's easier to locate. The next item of SB 95 is Section 4, and that relates to existing Section 78046. And what this does is allows a corporation in its bylaws to require that matters of certain federal jurisdiction or federal law be heard in specific federal courts. This is somewhat analogous to our successful attempt to introduce state forum selection provisions that allowed a corporation in its bylaws to designate state court, Nevada State Court, as the exclusive jurisdiction for matters that relate to the internal governance of a Nevada corporation. Again, there are policy reasons why we wanted that to be the case. Obviously, we want our state courts to listen to and adjudicate matters relating to Nevada state law. And what this section is trying to do is just to allow, not require, but just to allow a corporation to require jurisdiction on certain federal law matters to be heard in federal law. Item 5, or Section 5 of SB 95, merely tries to clarify that Nevada, in its state as a multi-constituency state, where the board is permitted to consider a wide range of factors, not just the interest of the stockholders, when in doing so is allowed to take into consideration the list of items contained in 78-138, but is not limited to. So we just clarifying that that's not a preclusive list, that's just merely an exemplary list, and that the board has the discretion to consider other factors just as much as those that are listed. The next area relates to distributions to stockholders. Sections 6, 9, and 10 of the bill. And in these sections, we thought it was appropriate just to clarify and make a distinction and recognize the fact that a corporation has more than just one class of stock. There's a general reference that distributions shall be made to stockholders of the corporation, when in reality, most folks are accustomed to corporations that have common stock, that have preferred stock, that have Series A, B, or C stock, and where all those different classes or series have unique and have preferential rights to a variety of things, including distributions. So our revisions to 6, 9, and 10, as evidenced by 6, 9, and 10 of SB 95, merely are reflective of the current practice of corporations to allow distributions to different classes or series. And that was just the goal of our revisions here, just to acknowledge the current practice and kind of update the language that was currently in effect. The next item relates to sections 11 and 14 of SB 95. And again, it relates to virtual stockholder meetings, but it's not as though those were not permitted already. In prior sessions, it was made clear that a corporation can hold a meeting virtually, exclusively so. And obviously, during the last 12 to 15 months, that has been a distinct transition with respect to stockholder meetings and the method of the way they've been conducted. That being said, there were some, as people were working through the realities of having stockholder meetings remotely instead of in person, there was certain language and terms and phrases that didn't quite work, and we wanted to make sure that the context was appropriate, such that the different requirements that related to notice to stockholders properly accommodated the fact that meetings can be held virtually on an exclusive basis. And then sections 12 and 14 also relate to stockholder meetings, and merely just provide clarification as to record date statements and distribution of additional information related to notices and meetings and adjournments. Item 13 of SB 95 relates to voting agreements. It relates to section 78365, which, if you look at the title, is actually only entitled voting trusts. But the substance of 78365 actually relates to voting trusts and voting agreements. And the purpose of our amendment here is to eliminate, or not eliminate, but to allow parties to enter into stockholder voting agreements that have a term in excess of 15 years. Currently, to the knowledge of some, but to unfortunately not to the ignorance of others, there is a hard cap of 15 years on the stockholder voting agreement per statute. And we thought it was about time that there was no need to have such a hard ceiling on that number to the extent that the parties agree otherwise. And so what we've done is we've just included language, we revived 365 to allow parties after the transition date, i.e. typically October 1st of this year, to the extent past, amend their agreements so they can provide for a date that extends beyond a 15-year term. It is actually quite, maybe not quite common, but when voting agreements do come up, it is common that people are not aware of the 15-year limitation on this duration. We hope to provide a framework for people to extend that and revise it if they need to. Section 14.5 is merely a just clarification item where there's a 10% threshold for making motions and for petitioning the court to appoint a receiver or trustee, and we merely wanted to include the words at least 10%, so 10% or more, just so it is read a little better than it currently did. Section 15 of SB 95, again, is not a substantive change. It merely adds a manager of a limited liability company as a capacity that an agent of the corporation can serve in and still benefit from the indemnification provisions of a corporation and serving on its behalf. Section 16 was submitted at the request of the real property section because they're related to 81-430. We agreed to include this as part of our bill, but it does touch upon certain corporations and associations under NRS 116. And the only true change we're trying to make is to accept from the membership certification requirement of certain associations and corporations under NRS 16 from that requirement. And the reality is many of these associations do not actually issue paper certificates or have any other physical manifestation of membership. And thus it was appropriate to exempt those from that requirement so that there is no latent defect in terms of how they're operating or any claim that they could be operating improperly. So we thought that was relatively unobjectionable and appropriate to recognize the common practice. The next area of the bill is relatively significant, I'd say. It covers sections 17 to 27 of NRS 95, and it covers the concepts of distributions and voting rights and relative rights of members in limited liability companies. And these changes were prompted by the changes that we made in Chapter 78 as it related to distributions. We thought, well, let's take a look at how Chapter 86 handles it. And we realized that there is no definition for distributions in Chapter 86. And then in doing so, we also noted that the relative rights of members in Chapter 86 was a function of essentially two things. One's contributions and one's rights to shares of profits in the LLC. And we thought that was appropriate to add a definition for distributions, and we thought it was appropriate to actually not have varying default rules as it relates to how you determine the rights of members. And so we went with the contribution concept as being the default rule for members and determining their relative rights rather than the rights to profits. And so in our revisions, if you see a section in particular, is section 18 kind of is where we set forth the default rule in terms of determining the rights of members with respect to their interests. And interest is a function of their contributions to the capital of the limited liability company. When reading that, one would think that references only cash contributions, not other contributions, but NRS 86-321 is very clear that one's contributions to the capital of the company include cash, include property, include services, includes a wide range of items not limited to cash. And so obviously, during the Senate side, we amended the bill to include 22.5, which made clear that that definition applies throughout the chapter. And again, as Senator Orenshaw mentioned, Section 22.5 will be further amended to make absolutely clear that any contributions to the capital of the LLC include both tangible and intangible property that is contributed by a member. So again, there's no intention, and it is a very clear statement that LLCs, the contributions to LLCs is very broad, and it's not limited to cash, not limited to tangible property, but related to any benefit and any intangible rights as well that can be contributed to members. And then Section 19 of SB 95 talks about distributions and basically tries to just set a baseline standard as to what distributions are, which are transfers of property to the members in accordance with their interests. But again, like many portions of Chapter 86, the parties can and often do enter into their own agreements and their own standards with respect to distributions and other rights vis-a-vis members and the LLC itself. The next area relates to sections 28 to 31 and 37 SB 95, and they relate to dissenters' rights. And what we're doing here is in the context of transactions where the votes are being solicited or obtained via written consent versus a noticed meeting, which is consistent with the methods of approving transactions under Title VII. In the written consent context, that the parties to the transaction have the ability to reach out, obtain advance notice, so to speak, of those stockholders that have the intention of exercising their dissenters' rights. We thought this would be an appropriate and useful function because it helps the parties quantify the cost of a deal. Many times transactions that are subject to dissenters' rights and the ultimate valuation of those shares underlying the dissenters' rights, they usually have limitations on how many shares can be properly perfected to have those rights, maybe 5 or 10% at most. And so what this does is it allows the parties to assess the extent and scope of that post-closing obligation liability and provides more deal certainty and ability of parties to go forward, we think more so than before. Section 32 and 35, again, there are minor cleanup revisions to the references to domestic corporations and publicly traded corporations in the context of our dissenters' rights. All it does is just help streamline the defined terms being used. And then section 33 and 34 pick up on the changes that we made in Chapter 86 as it relates to the relative rights of members of an LLC being based on their interests. And we've carried those forward with respect to the default voting requirements for limited partnerships and limited liability companies under Chapter 92A as it relates to statutory business combinations. And then Section 36 of the bill, this relates to notifications of rights to dissent. And we just wanted to make sure that the statute was clear as to what event actually triggers the time frame for a notice of dissent to be sent to stockholders. There was some ambiguity as to when exactly, so we thought it was appropriate just to make that change in Section 636 of SB 95. So that concludes my prepared remarks, and I'm happy to answer any questions that the committee may have. Thank you very much for allowing me to present this on behalf of the State Bar Business Law Section. Thank you.
Thank you so much for your presentation. Mr. Kim, thank you for walking us through the bill, and thank you, Senator Orenshaw and Ms. Warren. Now, back in 2017, it was the first time I chaired this committee, and I relied heavily on former Assemblyman Elliot Anderson, who was our business law expert. I could always count on him to have several questions on a bill like this. Unfortunately, he is not here with us, and last session in 2019, it was Assemblywoman Shea Backus who often had a number of questions on a bill like this. So just wanted to acknowledge both of them publicly and to tell them that we certainly miss them here at the legislature, and I miss having them on the Assembly Judiciary Committee. But with that being said, I think we do have a few questions. We're going to start with Assemblywoman Cohen.
Thank you, Chair, and thank you for the presentation. My question is about Section 4, the the federal forum selection section. I just want to check, does this affect on the ground the rights of Nevadans as they're dealing with corporations?
Robert Kim, again, on behalf of the State Bar's Business Law section. What Section 4 is meant to do is merely meant to provide the corporation with some predictability as to where certain claims can be heard. And so, again, I don't know if it change. I guess it would change going forward once adopted. It would change the venue to the extent that a corporation elected to require certain matters relating to federal jurisdiction to be heard in certain delineated federal courts as provided for in the bylaws, as the corporation is allowed to do so. This idea of tying jurisdiction to federal matters was developing, as was the state court, or the internal affairs kind of doctrine, and tying that to state court was as well. Those were developing somewhat concurrently, but we as a committee, we thought it was appropriate to go forward with the internal affairs state court concept first, and then wait to see how courts had viewed this particular construct. And in the last year, based on some recent Delaware Chancery Court decisions, it was made relatively clear that this construct was permissible as well, and within the discretion of the board to do so. And so we thought it was appropriate at least to give Nevada corporations the option to include that in their bylaws. What it's meant to do is to take courts with subject matter experience in federal matters and have those subject matters be heard in those courts, versus having matters filed in the wrong court and then having the parties have to either face motions to remove or other venue changes along the way. So our goal is just to make sure that the right courts are just hearing the right matters, or have the ability to, if the corporation deems it appropriate to do so.
Okay, thank you. But so I guess what I want to know is on a very basic level of our constituents, if they're in a lawsuit with a corporation, how does this change affect? Is it just getting them to the right court first, or does this affect which court they go to, and whether or not they have a say in that, or if it's just the corporation that has a say in that?
Robert Kim again, for the business law section of the State Bar of Nevada. What if the corporation were to take advantage of the statute, then they could merely indicate the court that the federal actions would need to be filed in. So the plaintiff, a stockholder, would then be required to file that action in that federal court versus in state court. And so that would be the change that would affect a stockholder in as it relates to this provision.
Okay.
It would merely tell them which court to go to.
I'm sorry, can you say that again?
It would merely advise the stockholder which court that action would need to be filed in.
Okay, thank you.
We'll go next to a question from Assemblywoman Summers Armstrong.
Good morning, and thank you for the presentation. Mr. Kim, The expansion of indemnity to the managers of the organization as laid out, I believe it's in 34. Can you kind of explain to us why this was expanded? Generally, it's more your executive directors, and I was just found this curious why it's being expanded. Thank you.
Thank you. Robert Kim again for the business law section of the State Bar of Nevada. So I'm looking at section 15 of SB 95 relating to section 787502. And what this is meant to do is just to acknowledge the fact that as a officer or director or representative of a corporation, or as a person, you might serve as an officer or director of a corporation. You also might serve as an appointed board member or appointed manager of a subsidiary or of an investment in an LLC that is downstream, so to speak. And so all we were trying to do is acknowledge the fact that corporations own a lot of LLCs, and usually that's their subsidiary of choice in a way. And so we're just covering the capacity of a member of a corporation, of either an officer or director of a corporation that has been asked to serve as a manager of a limited liability company on behalf of the corporation, that this capacity just be specifically set forth in 787502.
Chair, if I might have a follow-up?
Please go.
This is not my area, but at first blush, it just seems to give an unfair advantage to someone if they hold multiple roles, then they can possibly be a bad actor and have all kinds of indemnity. And I think that's just a little bit of concern. So if you could speak to that, thank you.
Yes, no problem. Robert Kim again for the business law section of the State Bar of Nevada. I guess I would respond to that concern in two ways. First is I don't think, even without including this reference, a corporation has the discretion to indemnify its representatives and agents in various capacities that person is being asked to serve. But I think more importantly, the standard of indemnification doesn't change just because they serve in different roles. The standard of indemnification, one, is discretionary on behalf of the corporation. And then if it decides to indemnify someone, that person, to be entitled to that indemnification, generally needs to be taking actions that are in the best interest of the corporation and takes actions that are believed to be in good faith. So the mere expansion of the roles that are permitted to be indemnified, again, I don't think increases the ability of a person to be a bad actor. And secondly, regardless of how many roles one has and whatever hats and colors, shapes, and sizes those hats may be, that person is still held to the same standard. They need to act in good faith and in the best interest of the corporation, regardless of what it is they're doing. So that baseline shall always be the case, and that's part of our statute, and that's being unaffected by what we're proposing today.
Thank you, and I'll note for the record that Assemblywoman Bilberry Axelrod has joined us. Good morning. We are on Senate Bill 95, and I'll ask a question that I have, Mr. Kim. In Section 13, which talks about the stockholder essentially entering into a voting agreement, and right now it's 15 years is the cap, and I understand what you're trying to do in the bill. I just wondered if you could give us a sense of why a stockholder would want to enter into an agreement for that long of a time period. If you just have some examples, is it a matter of convenience, or just wondering why it wouldn't be more typical for a stockholder to have a shorter agreement that could just be renewed on a regular basis?
Yes, Robert Kim, again, for this business law section of the State Bar of Nevada. So a few members of our committee have dealt with this issue and have dealt with parties just being unaware. First, just being unaware of the 15-year requirement or the 15-year ceiling or limitation on the term. And so even if there were built-in provisions that permitted extension, if you read the statute, it really doesn't accommodate the will of the parties to go beyond the 15 years. And so again, what we're trying to do is we're retaining the 15-year concept, not trying to change the rules necessarily on individuals. But once this is effective, the parties can then go back and amend their voting agreements, that is, to provide for and take advantage of the fact that terms can be longer. 15 years does seem like quite a long period of time, but there are cases, very recent matters that I've had to deal with that where that time frame has already been passed and people have disputes and they're unaware that these agreements are no longer effective, and basically at that point it's a bit of a mess, obviously, because then people are now only relying on principles of equity, reliance, and other items to really establish their rights and resolve their disputes. So I think it's appropriate just to make clear that parties can enter into agreements that have a longer term.
Thank you, Mr. Kim. And then the other question I had for you was about the amendment that was presented by Senator Orenshaw. I just wondered if you could tell us what the concern was that prompted the amendment and how the amendment addresses that concern.
Robert Kim for the Business Law Section of the State Bar of Nevada. Yes, I'll be happy to provide the context. I think, obviously, whenever you make changes to default rules or expectations of what people believe are the rules, there's a lot of questions and a lot of concerns, and obviously people wanting to make sure that best intentions yet don't yield unfortunate results. And so many questions that we received just related to the fact that what is the capital of what is the contribution of a person to the capital of an LLC? What is that concept? It sounds like it's just money. It sounds like it's something tangible, as I mentioned in our presentation. And so in cross-referencing section 86-21, our first attempt to just make sure to clarify the situation was to say that for the purposes of this chapter, i.e. entirely 86 in its entirety, the contribution of the contribution to the capital of the LLC is this definition, which is very broad, and I can read it to you real quickly just to pick up on a few words here. Just give me a moment to get to that section. So I'll make reference to the way it was originally drafted and then make reference to the amendment. And I think the amendment just is a further reiteration of the concern and a further clarification of the intent. But initially, 86-321 referenced contributions to the capital of an LLC as consisting of property or services or promissory note or other obligation to contribute cash, property, or services. In response to some concerns about does that really capture everything, we did look to Chapter 87A, which references contributions to the capital of a limited partnership. And in that section, there was it had its own description of what contributions to the capital were, and we thought on balance, just to make sure there was no confusion, that we would pick this definition and adopt it in Chapter 86. And now the definition as read and amended by the proposed mock-up to 22.5 says that a contribution to the capital of a member to the limited liability company consists of tangible or intangible property or other benefit to the LLC or the series, including, without limitation, money, real or personal property, services, performed, or a note or other obligation to contribute cash, property, or services. So I think in the end, we've come to, through this mock-up and additional amendment 22.5, a very clear, unequivocal, broad statement as to what it is a member's contribution to the capital of a LLC can be. Because obviously it's not our intent to not, by statute at least, recognize the wide range of contributions that can be made, whether it's cash, whether it's just the idea, whether it's contacts, whether it's someone's credit rating, as was discussed yesterday with one of the assembly persons. So it's meant to just be as broad as possible because every contribution it has value and should be recognized.
Thank you, Mr. Kim. Are there additional questions from committee members on Senate Bill 95? Okay, I don't see additional questions at this time. I want to thank the three of you for presenting the bill. I'll ask you to sit tight for just a couple of minutes and we'll take testimony on the bill and then we'll have a chance for concluding remarks. At this time, I'll open it up for testimony in support of Senate Bill 95. Is there anyone here in the room in Carson City who would like to testify in support? I don't see anyone coming forward here in the room. I don't believe we have anyone else on the Zoom with us in support. BPS, could we go to the phone lines to see if there's anybody else there in support?
Yes, Chair. To testify in support of Senate Bill 95, press star 9 now to take your place in the queue. And we will begin with the caller with the last three digits of 124. Slowly state and then spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair Yeager, Paul Moradkin, MORADKHAN, Senior Vice President of the Government Affairs for the Vegas Chamber. We appreciate the work that has been done by the bill sponsor in the business law section of the State Bar. The Chamber supports SB 95. As you heard, it provides greater clarification, predictability, conforming changes, and modernization as it relates to Nevada's businesses. These proposed changes will allow Nevada to remain competitive with other states such as Delaware. Thank you for your time and consideration, Chair and members of the committee.
Thank you for your testimony, Mr. Moradkin. BPS, are there additional callers in support?
Yes, with the caller with the last three digits of 529, please slowly state and spell your name for the record. You will have 2 minutes and may begin. Caller with the last three digits of 529, press star 6 to unmute yourself and begin your testimony, please.
Good evening, or good morning. For the record, my name is Ken Evans, EVANS, and I'm the president of the Urban Chamber of Commerce. We're pleased to be testifying in support of Senate Bill 95 this morning. Also want to recognize the bill sponsor, especially the business law section, for reaching out to the Urban Chamber the last few sessions in order to make sure that we could participate and support legislation like this that keeps Nevada current and make sure that our state remains as one of the most attractive places to do business. Most importantly, we do have several of our members that often use LLCs in order to get structured. So we're glad that we continue to improve the ability to state the rules in a manner that provides predictability as far as their governing documents are concerned. So with that, thank you very much, Chair Yeager and members of the Assembly Judiciary Committee, and we ask for your support for SB 95. Thank you.
Thank you for your testimony, Mr. Evans. BPS, could we take the next caller in support, please?
Yes. With the caller with the last three digits of 505, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Chair Yeager and members of the Assembly Judiciary, my name is Peter Guzman, and I am president of the Latin Chamber of Commerce. I'm testifying in support of Senate Bill 95, and I'd like to thank Senator Orenshaw and the business law section of the State Bar for including the Latin Chamber on this bill for the last few sessions. It has been a brutal year for so many Nevada businesses, including some of my very own members. But SB 95 ensures that Nevada does not stop innovating. SB 95 gives additional clarity for LLCs, in particular, which is the most common and popular business entity amongst members. SB 95 also provides assurance that in this virtual world, companies are not caught up in legal technicalities when meeting virtually. Anytime we can keep business out of court for needless reasons promotes efficiency and prosperity. For me, plain and simple, this is a pro-business piece of legislation, and the Latin Chamber of Commerce is always happy to support pro-business piece of legislation, and that's why we're happy to support SB 95. I appreciate and thank each and every one of you.
Thank you for your testimony, Mr. Guzman. BPS, are there additional callers in support?
Yes, Chair. Our next caller with the last three digits of 062, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Yes, good morning. My name is Sonny, S-O-N-N-Y, Vinuya, V-I-N-U-Y-A. For the record, I'm the president of the Asian Chamber of Commerce. Good morning, Chair Yeager and members of the Assembly Judiciary. The Asian Chamber is happy to come to the virtual table in support of Senate Bill 95. I would like to recognize the Business Law section for taking the time to brief the Asian Chamber on this bill, as they have in the past few sessions. Now, SB 95 helps maintain Nevada's position as one of the most pro-business states in the nation. During these tough economic times, it's more important than ever to stay current and competitive with other states. Many of our members use LLCs, and SB 95 gives owners and managers better understanding when the LLC governing documents are silent or when the LLC has no operating agreement. The Asian Chamber would urge your support on SB 95. Again, thank you so much and have a great morning.
Thank you for your testimony, Mr. Vinuya. BPS, are there additional callers in support?
We are currently taking testimony on Senate Bill 95. Press star 9 now to take your place in the queue. Chair, there are no callers in the queue.
Thank you, BPS. I'll close testimony in support. I will now open testimony in opposition. Is there anybody in Carson City with us who'd like to testify in opposition? I don't see anyone coming to the table. Don't believe we have anyone on the Zoom. BPS, could we go to the phone lines to see if there's anybody in opposition, please?
To testify in opposition on Senate Bill 95, press star 9 now to take your place in the queue. Once again, to testify in opposition on Senate Bill 95, press star 9 now. Chair, there are no callers in the queue.
Thank you, BPS. I'll close opposition testimony. I will now open neutral testimony. Is there anyone in the room here in Carson City? Ms. Brown, welcome, and please go ahead.
Good morning. Thank you, Chair Yeager, members of the Assembly Judiciary. Tanya Brown, for the record. I wasn't even going to speak on this, but there's the subject of bad acts and good faith comes to mind. And I just want to give you a brief history of what happened in our situation. My mother passed away in 2011. Several years later passed, I received a letter. I thought it was junk mail because it was just a letter, had the address from Vegas and addressed to me. I mean, you'd get that in the mail. It's just, junk mail. For some reason, I didn't throw it away. I opened it up. I was being sued by an attorney was suing us because on behalf of a bank corporation out of state over some property that we owned. And it goes back to the year 2000. My mother and I owned some property together. She had taken a reverse mortgage out on the property, and then she got sick. Medicaid got involved, which is federal and the state. So my name had to come off the title. The transaction didn't get completed, and I had no idea. We had no idea until I received that letter. It turns out that I still owned part of the property. So I was being sued, and if I had not by the bank, if I had not responded in this letter, I wasn't served by law enforcement, it was just a letter saying that they've taken legal action and everything else. I had to respond. I contacted the attorneys down in Vegas and who was representing the bank. Ultimately, we had to go and I had to file in court in Lyon County went into court. I wound up having to sue the title company. They were suing me. Ultimately, we came to some decisions. So I know this doesn't really have too much to do with that, but I think when you're dealing with bad acts and good faith, the corporations, when they are hiring attorneys to look into this and you're being sued, they need to do it properly. Not send a letter with not stating they're an attorney, because if I had not responded, it would have ruined my credit and it would have gone against me. And ultimately, they ruled that I did own the property. But I would have lost it all. But I just wanted to say that in neutral, whether it has anything to do with that. But I think the corporations need to know who they're dealing with and make sure that it's done properly. Thank you.
Thank you for your testimony, Ms. Brown. Anybody else here in Carson City in the neutral position? I don't see anyone else here. I don't believe we have anyone on the Zoom. BPS, could we go to the phone lines to see if there's anybody there in the neutral position?
Yes. To testify in the neutral position on Senate Bill 95, press star 9 now to take your place in the queue. And we will begin with the caller with the last 3 digits of 313. Press star 6 to unmute yourself and then slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning. My name is Keith Bishop, Keith Bishop. I've been writing and following Nevada business entity law for about 30 years. I wanted to provide some comments on Section 4 of the bill, which would amend NRS 78.04, deals with forum selection provisions in either the articles or bylaws. The bill would allow the articles or bylaws to require that actions brought by the corporation or against the officers or directors of corporations to be only brought in specified courts in cases of what is known as concurrent jurisdiction. Concurrent jurisdiction is when a case could be brought in either federal or state court. Perhaps the prominent example of that is the Federal Securities Act of 1933, which provides that lawsuits involving the public offering of securities may be brought in either federal or state court. So those, when people buy in IPOs or in registered public offerings, they have a right to bring claims in either federal or state court. That's led some plaintiffs to forum shop. They may prefer to be in one court or the other. This bill would allow the bylaws or the articles to require that those kinds of actions be brought in a specified court. My concern with the bill is that it doesn't just bind stockholders, people who have actually purchased shares in the corporation. It would also extend to people who are merely offered shares. So if I were walking down the street and I offered shares and you're then an offeree, seemingly you would be bound by the articles or bylaws of the corporation that you're not even yet a stockholder of. It would also apply to subscribers. Again, these are people who have agreed to buy shares but haven't actually become shareholders yet. So I think that's problematical. Another problem with this provision is that it would seemingly
Mr. Bishop,
people...
Mr. Bishop, if I could
Yes.
interject for just a moment. If you're expressing concerns about the bill, I'm going to characterize your testimony as opposition rather than neutral. Neutral as if you really have no position on the bill. So I'm going to do that at this time, and we are over your 2 minutes, so I would just ask if you could please wrap up your comments.
Okay. Yeah, I'm not, just to be clear, I'm not against the policy of the bill or the bill itself, but I do have some technical comments, and that's why I thought it appropriate to characterize my position as neutral. At any rate, I would just want to point out, and I'll close very quickly, is the bill would seemingly require stockholders who are bringing lawsuits totally unrelated to the corporation against officers or directors to be bringing those suits in the forum specified in the articles, which seems a bit quirky to me. Thank you for your time.
Thank you so much for your testimony, Mr. Bishop. BPS, do we have additional callers in the neutral position?
We are currently taking testimony in the neutral position on Senate Bill 95. Press star 9 now to take your place in the queue. Chair, there are no callers in the queue.
Thank you, BPS. And before I close neutral, I will note for committee members and members of the public, there is a statement from the Nevada Secretary of State's office on Nellis that is formally neutral on the bill as well. So you can find that under the exhibit tab in Nellis. I will now close neutral testimony, and I will hand it back over to our presenters to make any concluding remarks on Senate Bill 95. Senator Orenshaw, would you like to begin?
Thank you very much, Chair Yeager, and thank you, committee, for your close attention to Senate Bill 95. I believe Senate Bill 95, if passed, would help business development here in Nevada and help us be competitive with other states. I certainly want to thank Mr. Kim and Mr. Kovacs, Albert Kovacs, Robert Kim of the State Bar of Nevada Business Law Section, Mackenzie Warren, for reaching out to so many stakeholders, trying to work on different issues and get the bill to this point. I want to thank the legal division, Mr. Anthony and Mr. Wilkinson, for their help in getting us a mock-up so quickly that the committee could look at. And I appreciate the committee's time. Thank you.
Thank you, Senator. Ms. Warren, would you like to make any concluding remarks?
Thanks, Chair Yeager. Mackenzie Warren for the record. We just echo what Senator Orenshaw said. This is a session unlike any other. It's highly technical. This bill is complex. LCB helped us get it right. Thank you.
Thank you, Ms. Warren. And Mr. Kim, any final words before we close the bill hearing?
Yes, Robert Kim, Business Law Section, State Bar of Nevada. Just wanted to again echo the thanks, Senator Ornshaw's sponsorship for our bill, and the attention and time taken by the Assembly Judiciary Committee in this bill in particular. And to know for the record, we have worked with Mr. Bishop in the past, and I'm happy to have additional conversations with him as well on the items noted. And obviously, he's looked at Nevada laws for quite a while, as he stated. And so obviously, we look to speak with Mr. Bishop, in the ordinary course, in a productive manner, to obviously make our laws in Nevada the best we can make them. So I look forward to future conversations, and I look forward to the actions to be taken by the Judiciary Committee. Thank you.
Thank you, Mr. Kim, and thank you to the three of you for spending some time with us this morning in Assembly Judiciary. Hope you have a really fantastic rest of the day and rest of the week. And Senator Orenshaw, I'm sure we'll be seeing you back in Judiciary again soon.
I hope so. Thank you very much. It's always a pleasure to be in front of this committee. Thank you, Mr. Chair.
Thank you. So I will close the hearing on Senate Bill 95, and that takes us to our first listed bill on the agenda. I will now open the hearing on Senate Bill 41 in its first reprint. That bill revises provisions relating to orders authorizing the installation and use of a pen register or trap and trace device. We have Ms. Adair with us here in person and Ms. Har on the Zoom with us. Thank you both for your patience this morning. I know sometimes it's disappointing to come in and your bill's listed first but gets taken last, but we just appreciate your flexibility, appreciate you being here. When you're ready to proceed with the presentation of the bill, please go ahead, and then I'm sure we'll have some questions for you.
Thank you, Chair, and no problem at all. I learned quite a bit in this hearing. Thank you, Chair. Good morning. My name is Jessica Adair. For the record, I appreciate all of you at the committee hearing Senate Bill 41. First Assistant Kyle George had to, I believe he was on the Zoom earlier, he had to leave to go to Government Affairs. But I, if with the Chair's permission, would like to turn the virtual mic over to Special Assistant Teresa Hart to present Senate Bill 41.
Thank you. Welcome, Ms. Har. I know we've spoken on the phone before, but I don't know that we've ever met in person, so it's nice to meet you virtually, at least. Welcome to Assembly Judiciary, and please go ahead.
Good morning, Chair Yeager and members of the committee. Thank you for your time. For the record, I'm Teresa Har. I'm the Special Assistant Attorney General, and I'm here on SB 41. As a preliminary note, the amended language in this bill has been arrived on after meetings with a number of stakeholders, including the Nevada Sheriffs and Chiefs Association, ACLU of Nevada, Clark County Public Defender's Office, Nevada District Attorneys Association, Nevada Attorneys for Criminal Justice, Nevada Police Union, and Nevada Association of Public Safety Officers. And we appreciate collaboration with those groups on a number of the AG's bills, and I just wanted to note our appreciation for that first. Under existing law in NRS 179.530, district courts in Nevada have jurisdiction to issue orders authorizing the use of PIN registers and trap and trace devices. And by way of background, a PIN register is, it identifies all phone numbers that have been dialed outgoing by a telephone, and a trap and trace device identifies all incoming phone numbers dialed by a telephone. And a PIN register and trap and trace do not record the contents of any communications in that device. And this proposed bill makes a few changes to the mechanics of the application, but not to the contents of the application or to the scope of any information available to be obtained through the use of a PIN register or trap and trace device. Under current law, district courts issue the orders upon application by a member of a district attorney's office or member of the Office of the Attorney General based on an affidavit from a peace officer. This proposed bill seeks to include in the definition of peace officer federal officers who are members of task forces with state and local law enforcement officers. This bill would also allow either the member of the district attorney's office or the attorney general's office with a supporting affidavit from a peace officer or the peace officer himself to apply for the court order allowing for the installation of the PIN register and trap and trace device. The proposed bill also seeks to bring the mechanism for submitting an affidavit into the modern world by allowing for electronic submission for the supporting affidavit and application. And particularly in, as we've seen over the past year, a need for electronic submission is very helpful when courts are physically closed. Under current law, there's no specification as to whether electronic submission is permissible, and it really varies from court to court. And so this will make for a consistent process statewide, and will also be similar to the secure electronic transmission provision as it currently pertains to submission of search warrant applications. And lastly, this proposed bill eliminates the date specified for the federal statute that is incorporated by reference. As the federal statute gets updated from time to time, that way we don't need to come back here and request updates to the statute every time the federal provision changes. And so before I close, I want to thank the committee for your time here, and I welcome all questions.
Thank you for your presentation, Ms. Harn. I just wanted to ask a quick clarifying question. You addressed this at the beginning, but I'll be candid and say my mind was elsewhere for a moment. So you talked about a pen register and trap and trace device, and I know those are defined federally under the U.S. Code, but I wanted to confirm those simply capture the numbers, one of them being the pen register is the numbers that are dialed out from a phone, and a trap and trace records the numbers that are calling into a phone. Did I get that right?
Yes, that's correct. Teresa Hart for the record. That is a correct generalization. With your indulgence, under 18 U.S.C. 3127, which is the federal definitions, we have incorporated those by reference into this new provision. A pen register is a device or process that records dialing, routing, addressing, or signaling information. However, it does not include any contents of the communication and does not include any device or process used by a provider for billing. And similarly, a trap and trace device is incoming information as opposed to outgoing, but again, does not contain the contents of any of those communications.
Thank you for that explanation. And let me just ask a follow-up, and I certainly don't want you to reveal any information you're not at liberty to reveal, but can you give me an example of an investigation that would benefit from the use of a pen register or a trap and trace device? I understand that you need to get a warrant for it, but I think maybe it'll help the committee if you can just give an example or two of when a warrant like this might be sought and what the context would be.
Great, thank you. Teresa Hart for the record. Where we see pen registers and trap and trace devices most commonly is, so the standard for it, first preliminarily under the federal provision, is it has to be related to an ongoing criminal investigation. And so we're simply looking for communications between two individuals. And part of why this is incredibly helpful is once we look at the entirely separate heightened wiretap application standard, you have to demonstrate that you have done all of your due diligence in less intrusive and less invasive means. And that usually includes pen registers and trap and trace devices. And so this will allow, if you have someone that you suspect has committed a crime, you can look at their communications with other individuals, which, based on the phone number of who they're regularly communicating with, might give you more information as who else may have been involved based on the information that you're obtaining during your ongoing criminal investigation.
Chair Yeager, if I may. Jessica Adair for the record. Teresa did an excellent job explaining the federal definitions of the pen register and trap and trace and how they are commonly used. I just want to answer your question, wanted to give you a hypothetical. So one of the criminal acts under our jurisdiction in the Attorney General's office is insurance fraud. And commonly we see what are staged accidents. So someone conspires with another person to have a car accident and then bill the insurance company for damage to that vehicle. So if we suspect that this a car accident is in fact a staged accident for the purposes of insurance fraud, and we have reason to believe that these two drivers of these vehicles are working together for other facts and circumstances that lead us to believe that. But when we interview these people, they say, I've never met this person before in my life. I'm just driving my vehicle and they hit me. We might, based upon these other facts and circumstances, put in an affidavit and apply to the court to have a pen register or trap and trace device tell us if these people are calling each other and planning this accident. And it also shows us that in this interview, when we have asked them, do you know this person? And they said, no, I don't know this person at all, that they are lying to us. And that helps us in our investigation of the staged accident. Do we know what they've discussed on the phone? No. The pen register and trap and trace device, as Teresa Har stated, do not tell us the contents of a communication. It's just like looking at your phone and you can see the calls that you've dialed and the calls that you've received, those phone numbers and the time of the number of minutes that the call took. That's the only information that we could see from these devices. So thank you for that question. It is a very important clarification because I want to make sure that the committee understands that what we're seeking to do here has nothing to do with a wiretap.
Thank you for that example. I think that was helpful. We're going to go now to some other questions. I think Assemblywoman Summers Armstrong, we'll go to the first question there, and then I know we'll have others.
Thank you, Chair Yeager. Thank you, Ms. Adair, Ms. Har, for your presentation. I saw that you've added that the peace officer can directly ask for this. Could you please expound on why? Because the example that you just gave seems to be when you're doing something coordinated, when your office is doing something, when there's a federal coordinated investigation. I'm concerned about a peace officer of their own volition going forward and asking for a warrant, and I'd like to know why you all added this. Thank you.
Thank you, Teresa Har for the record. As a preliminary note, under NRS 179045, in that general section as it pertains to search warrants, law enforcement officers are permitted to apply directly for their own search warrants. They don't have to rely on their attorney. It is only once you get into the wiretap application that the attorney is required to submit the application. And so we are looking to make this in conformance generally with the warrant application. And beyond that, under the federal provision, it states expressly that under 18 U.S.C. 3122, state law enforcement officers are permitted to make direct applications, not going through their attorney, as long as state law does not expressly prohibit it. And so we wanted the opportunity to clarify that our state law does not expressly prohibit that.
Chair, follow-up, please. Would you please, Ms. Har, restate the NRS that you referred to a little bit slowly?
Yes, it's in chapter, Teresa Har for the record, it's in chapter 179. It's in the warrant provision. the law enforcement officers can make direct application for the warrants themselves.
Assemblywoman, we'll be happy to send you that exact citation after this, at the conclusion of this hearing.
Okay, do we have additional questions? Assemblywoman Cohen?
Thank you, Chair, and thank you both for the presentation. I have a question on the immunity section. The civil immunity section is Section 1, Sub 5, for a public utility that relies in good faith upon an order authorizing the installation and use of the register and the trap. I get why we need for utilities to have some sort of immunity when they're relying on what they've been provided, but how do they physically get the traps into the system, right? I guess what I'm getting at is if they're not walking onto anyone's property where they could possibly break anything, or and then they've got immunity and they destroyed someone's yard or something like that. It's all done from their facilities.
Teresa Harp, for the record, I do want to note that the new Section 5 regarding public utilities is currently in the statute. It was previously Section 3 down below. It was just moved in the section, but that is correct. Generally speaking, cell phone providers and utility companies rely on the pen register trap and trace installation at their own facilities. They're not generally going onto people's private property to install anything.
Thank you.
A question from Assemblywoman Krasner.
Thank you, Chair Yeager. I was just looking at Section 1, Sub 5 of the bill. I was just wondering, first, why are public utilities included there? Thank you.
Teresa Hart, for the record, again, that section was already in the statute pre-existing. The public utilities are mentioned just as a phone company would be a utility company that would be included in this. But that section was pre-existing in the statute. It was only moved.
Okay, thank you for that. And I just had one other question. So say it's a public utility such as the electric company, and they're trying to see if somebody has a grow house, and so they're monitoring their activity of electricity used, but they're not finding any. How long would that trap and trace or pen device, whichever applies here, how long would that stay in place? I mean, is it a reasonable time, like a month or 2 months or 3 months, or is it we just suspect that house and we're going to leave that on there for a year? How do you determine that? Thank you.
Teresa Hart, for the record, if a pen register or trap and trace device is being put into place by a phone company to determine this, it is for a fairly short period of time, but there is a provision under the statute, and it's consistent with the federal statute, that allows them to reapply for it if they need additional time. But the time specified will be in the order.
Do we have additional questions from committee members on Senate Bill 41? Assemblyman O'Neill.
Thank you, Mr. Chair. Mr. Adair, would it be fair to say one of the reasons why officers are allowed to go directly to the district court with a sworn affidavit because of exigent circumstances, being 2 o'clock in the morning, to go to a district attorney, find the district attorney, delays that action, and that would be one reason, good cause for that. And it is a sworn affidavit before the judge. So it's not just a freedom to act, but that's why the officers are included in this?
Yes, Assemblyman. Jessica Dare, for the record. You're exactly right. So I want to be absolutely clear. This application is to a court, and a judge has to make a determination that there is enough facts and circumstances that have been provided under penalty of perjury to justify a pen register or trap and trace device. And the judge would also issue the time limit for how long that device would be allowed to be used by a phone company. But I want to talk just very quickly about why we included the direct application. To your point, it has to do with efficiency, but also when you think about the level of privacy that is involved with a pen register or trap and trace device and the warrant itself. When you're talking about a search warrant, so a peace officer is entering your residence and going through your property, your level of privacy is very high. But to get that warrant, a peace officer can directly apply to a judge and receive that warrant. They don't have to go through a district attorney. To get a pen register or trap and trace device warrant, you have to go through your district attorney and then to the judge. But the privacy interest in just the phone number that you've called or has called you is much lower than your actual property. And so to us, it just didn't make sense that there would be more bureaucracy to get the warrant for a privacy interest that's much lower than a search warrant for your house. So that's one of the reasons why we felt like making this consistent with a search warrant just made sense. And it is, to your point, it is also more efficient.
Thank you. Thank you, Chair, for the time.
You are welcome. Do we have other questions from committee members? Take one last look. It does not look like we have additional questions at this time. So Ms. Adair, Ms. Haar, thank you for presenting. We'll take testimony on the bill, and then we'll have a chance for concluding remarks. At this time, I'll open up the hearing for testimony in support of Senate Bill 41. Is there anyone here in Carson City who'd like to testify in support? I don't see anyone coming to the table. We don't have anyone else on the Zoom. BPS, could we go to the phone lines to see if there's anybody there who would like to offer testimony in support?
Yes. To testify in support of Senate Bill 41, press star 9 now to take your place in the queue. And we will begin with call-in user number 1. Please slowly state and spell your name for the record. You will have 2 minutes and may begin. Call-in user number 1, please hit star 6 to unmute and provide your testimony.
Hello, Mr. Chair, members of the committee. Chuck Callaway, for the record, Callaway, representing the Las Vegas Metropolitan Police Department, and we're here in support. Thank you.
Thank you for your testimony, Mr. Callaway. BPS, are there additional callers in support?
Yes. Would the caller with the last 3 digits of 648 please slowly state and spell your name for the record? You will have 2 minutes and may begin.
Thank you, Chair Yeager, members of the Assembly Judiciary Committee. My name is John Jones, John Jones, here on behalf of the Nevada District Attorneys Association in support of SB 41. I want to thank AG Ford, Chief of Staff Adair, and Special Assistant Haar for presenting the bill. SB 41 is a procedural cleanup measure, and we are in support. Thank you.
Thank you for your testimony, Mr. Jones. VPS, do we have additional callers in support?
Yes. Would the caller with the last 3 digits of 683 please slowly state and spell your name for the record? You will have 2 minutes and may begin.
Good morning, Mr. Chairman and members of the committee. My name is Rick McCann, RICKMCCANN, and I'm the Executive Director of the Nevada Association of Public Safety Officers and a member of the Nevada Law Enforcement Coalition. I'm here today in support of SB 41. SB 41 extends existing law used to fight crime with pen registers and trap and trace devices by giving the authority to obtain them to federal law enforcement officers who are members of state or local task forces. The bill, as amended, also fortifies the requirement that such devices be obtained by an order of a district court judge in this state. In other words, warrants are necessary. We're not getting away from that. As Ms. Haar stated, we were privileged to work with the AG staff and several other stakeholders to arrive at this good piece of legislation, and we urge the committee's support of SB 41 as amended. Thank you.
Thank you for your testimony, Mr. McCann. BPS, could we go to the next caller in support, please?
Yes, to provide testimony in support of Senate Bill 41, press star 9 now to take your place in the queue. Once again, to provide testimony in support of Senate Bill 41, press star 9 now to take your place in the queue. Chair, there are no more callers. Oh, stand by. All right, we're going to move on to the caller with the last 3 digits of 196. Please slowly state and spell your name for the record. You will have 2 minutes. I may begin.
Good morning, Chairman Yeager and members of the Assembly Judiciary Committee. I'm Eric Spratley, S-P-R-A-T-L-E-Y, the Executive Director of the Nevada Sheriffs and Chiefs Association, here in support of Senate Bill 41 and appreciate the Attorney General's office bringing this important bill today. We thank the committee for considering this bill. Thank you, Mr. Chairman.
Thank you for your testimony, Mr. Spratley. BPS, I don't think there are any other callers in support, but could you please confirm that?
Yes, to provide testimony in support of Senate Bill 41, press star 9 now to take your place in the queue. Chair, there are no callers in the queue.
Thank you, BPS. I'll close testimony in support. I will now open it up for testimony in opposition. Anybody here in Carson City in opposition? Nobody is coming to the table. We don't have anyone on the Zoom. BPS, could we check the phone lines to see if there's anybody there in opposition?
To testify in opposition of Senate Bill 41, press star 9 now to take your place in the queue. Once again, to provide testimony in opposition of Senate Bill 41, press star 9 now. Chair, there are no callers in the queue.
Thank you, BPS. I'll close testimony in opposition. I will now open it up for testimony in the neutral position. We'll start here in Carson City. Ms. Brown, please go ahead.
Thank you, Chair Yeager. Tanya Brown, Advocates for the Inmates and the Innocent. We are in neutral, and in part, Assemblywoman Krasner kind of touched on why we would be in neutral. Let's say hypothetically, someone is living in the house and the public utilities see something growing in the backyard. Do they do a thorough and complete investigation as to who is actually living in the house? It could very well be a person's loved one who may have some illness that they are allowed to grow medical marijuana, but it's not registered because they just moved in. Do they actually check to find out who's doing that? Other than, oh, they're growing it, so it has to be the owner. And then there's the text messages too. So the text the phone calls going in and out could very well be the son taking care of the mother, contacting family members. They know she's doing okay, but it could show that maybe they're doing drugs or whatever. So we are in neutral on this. I think that needs to be. I'd like some more information on that as well. Do they actually look at the with the state, who's on medical marijuana, who's living in the home, those kind of things. Thank you.
Thank you for your testimony, Ms. Brown. Anybody else here in Carson City in the neutral position? No one's coming to the table. We don't have anyone else on Zoom. BPS, could we go to the phone lines to see if there's anyone in the neutral position?
To testify in the neutral position on Senate Bill 41, press star 9 now to take your place in the queue. Once again, if you would like to testify in the neutral position on Senate Bill 41, press star 9 now. Chair, there are no callers in the queue.
Thank you, BPS. I'll close neutral testimony and would now invite Ms. Adair back to the table here in Carson City. And we again have Ms. Haar on Zoom and would invite the two of you to make any concluding remarks on Senate Bill 41. Ms. Adair.
Thank you, Chair Yeager and the committee. Jessica Adair for the record. I just want to make one very quick clarification. The public utility that is referred to in this bill is only phone companies. The pen register and trap and trace device do not apply to anything other than telephones. So the public utilities would not include electricity, gas, or any other utility, only phones. Also, the public utility or phone companies cannot unilaterally install these devices. They only can do so under a court order. But with that clarification, I just want to thank you and thank the committee, and also thank our many stakeholders who helped us come to the best version of this bill, and we really appreciate your time.
Thank you. Ms. Haar, any concluding remarks?
No, I just want to, Teresa Har for the record, I just want to thank the committee for your time and consideration this morning. We appreciate it very much.
Thank you to the two of you for presenting, and as chair, I just want to express my appreciation. I think the bills that you've brought forward this session have obviously been worked on before they arrived here at the legislative session, and that makes our job easier. So I really do appreciate the hard work. I know it's not always easy to get all those people in one room and try to get them to agree, but that work is not unnoticed and certainly appreciated. So thank you again for being here this morning, and have a great rest of your day. I'll close the hearing on Senate Bill 41. That takes us to our final item on the agenda, which is public comment. By way of reminder, we reserve up to 30 minutes at the end of each meeting for public comment. Public commenters will have 2 minutes to provide public comment, and public comment is a time to raise matters of a general nature within the jurisdiction of this very hardworking Assembly Judiciary Committee. So we'll start with public comment here in Carson City. Would anyone like to give public comment this morning? Ms. Brown, Mr. Viesca? Any public comment? Mr. Finseth? No public comment here in the room. BPS, could we go to the phone lines to see if there's any public comment there?
Yes. To make public comment, press star 9 now to take your place in the queue. And we will begin with the caller with the last 3 digits of 556. Please press star 6 to unmute yourself and then slowly state and spell your name for the record. You will have 2 minutes and may begin.
Anne Marie Grant, ANNEMARIE, sister of Thomas Purdy, who was murdered by Reno Police and Washoe County Sheriff's Office during a mental health crisis. My brother was just one of several men in your state asphyxiated by police. There was also Tashi Brown, Nico Smith, Justin Thompson, Roy Scott, too many to name, and they all deserve justice like George Floyd's family got. And seeing the killer cop convicted, all 3 charges, brings a renewed hope to us families especially us families who did not even get a review of the murder by the district attorney's office. If anything, I feel like your attorney general or your Department of Safety, whatever, they need to investigate. I don't know how a federal investigation was never done into Washoe County when 14 plus people died at the jail within 2 years. People who were some awaiting their day in court, innocent until proven guilty, but tried, convicted, and executed by police. Please support bills that promote transparency and accountability. Please do not support bills that further protect police officers. If anything, I think we should repeal NRS 289. Thank you. Have a good day.
Thank you for your public comment, Ms. Grant. Any additional public comment, BPS?
Chair, there are no more callers in queue.
Thank you so much, BPS. Appreciate your hard work as always in helping us manage the remote testimony. I will now close public comment. Anything else from committee members before we talk about where we go from here? Okay, I don't see anything. Again, I want to thank you, committee. I know it's been a long week. We have 1 day yet left in this work week, so we do have a meeting tomorrow. Assemblywoman Kazama, would you like to make a comment?
I'd just like to thank our treasurer, Zach Conan. I went online to claimantnevada.org and I had property. So I encourage everybody to do it. I think it's only enough for a couple of cups of coffee, but it's there.
Thank you for that comment. I would certainly encourage anyone in the committee and anyone listening, run yourself on that website, run people you know, because it's a name-based search. You're going to find people that have unclaimed property, and so if you could let people know it's out there and it's theirs, they just have to go through the process. So please do encourage others to do that.
Yeah, Mr. Chairman.
Assemblyman Wheeler?
$16 here.
$16 will buy a couple dozen donuts down the street, so it sounds good to me.
Chair, you get 150.
100.
Chair, my grandmother found my mother for my grandmother found thousands. So people should know to check because it's not just small amounts.
I had $47 just last month.
Tanya, just give a thumbs up. Did you find some money as well? Or so, Miss Brown found some money as well. Mr. Finseth is in the room. He found some. It looks like maybe Mr. Vieska is the only one who hasn't yet run his name. There's probably money out there. Assemblyman Miller found. Everyone's finding money, so make sure to search. So in terms of the rest of the week, we do have a meeting tomorrow. It is at 8 o'clock. We have 3 bills. And then a reminder, committee, we have floor today. And one of the things I think is going to happen on floor is we're going to receive a whole lot of Senate bills coming over that will be referred to Assembly Judiciary. So I don't yet know what next week is going to look like, but I will certainly tell you tomorrow what Monday might look like, just waiting to see what we get, and we'll go from there. So thanks again, everyone, for a very entertaining Judiciary Committee meeting this morning. We'll see you back here in this committee room at 8 o'clock tomorrow morning. This meeting is adjourned.